Today, we're plunging headfirst into a topic that's absolutely critical for any business operating in South Asia, navigating the legal minefield of labor law compliance in Bangladesh.
And this really isn't just theory. If you run a business there, whether you're a small startup or a big multinational, you're governed by the Bangladesh Labor Act of 2006 and the rules from 2015.
Right.
But the real challenge, and what our sources are showing us, isn't just following clear rules. It's about surviving the ambiguities and the outright contradictions that are baked into the legal framework itself.
So our mission today is to give you a real shortcut to understanding these complexities. We're going to unpack those specific gray areas, the pitfalls that lead to fines, to employee unrest, or even court cases.
It's all about stabilizing your foundation because, compliance isn't just about avoiding penalties. It's about ensuring operational peace of mind.
Exactly. So let's start with a perfect example of this ambiguity. The government suddenly declares a general holiday. It happens all the time for, security reasons or something else.
Right.
Okay, so when that happens, what is a private company legally required to do? Is it like a normal public holiday where you have to pay extra?
Well, this is what's so fascinating. The term general holiday, it's basically an unregulated concept for the private sector.
Unregulated?
Yeah. The Labor Act doesn't define it. It doesn't give any protocol for private businesses to follow.
So if it's not regulated, does management really have total flexibility?
Yeah.
Can they just tell everyone to come in or close down without any premium pay? What's the real risk?
Legally, yes, management has that flexibility. There's no mandatory requirement in the act for double pay or overtime just because the government said so. But the practical reality, that's where the risk is.
Okay, give us an example.
Well, think about why these holidays get declared. Often it's because of things like curfews or major events that shut down transportation.
Ah, okay.
So management might want to stay open, but it becomes physically impossible for workers to even get to the factory or the office.
Right, so even though the law doesn't force your hand on pay, reality forces you to close. What happens to the payroll for that day then?
Management just has to handle it based on their own internal policy. But they aren't automatically required to pay a premium. The key takeaway for you here is that this is a management decision, not a statutory one like a festival holiday. It just shows how many critical decisions fall into these sort of legal silences.
Okay, so if ad hoc decisions are messy, let's move to where companies try to build some stability. Their formal service rules. Is it actually mandatory to have an HR manual or a service rule book?
That's a really common misconception, and the short answer is no. Service rules are absolutely not mandatory. Section 3 of the law just allows companies to create their own.
But if a company does decide to create one, and most do, what's the one compliance point they absolutely cannot get wrong?
This is crucial. Any internal rule, whatever you call it, an HR manual or standing orders, it must not contradict the Labor Act by offering terms that are less favorable.
So you can't offer less than the legal minimum.
Exactly. If the law says 10 days of casual leave, your rule book can't say 9. You have to meet the floor, or you can go above it, but never below.
That seems straightforward enough. But I've heard that getting these rules approved is a huge bureaucratic nightmare.
Yeah.
Where does that process break down?
It's the mandatory approval process. Any custom service rulebook has to be approved by the Director General of the Department of Inspection for Factories and Establishments. We usually just call it DIFE.
And what's the timeline on that?
Well, the law says approval should take 90 days.
Shrug.
Right. But in reality, our sources say this can stretch on for much, much longer. We're talking years in some cases.
Years? Wow. So the very system designed to let you customize your rules actually discourages it through red tape. Why is it so slow?
It seems like a mix of things. Maybe administrative capacity, maybe just risk aversion. A lot of DIFE inspectors tend to demand that companies use the exact, often really archaic and complicated form language from the government templates.
Which defeats the whole purpose of making your own easy-to-understand rules.
It completely negates the purpose. You end up with a custom policy that just sounds like a piece of legal code, all to get a signature.
It just pushes businesses to sort of wait and see, which only creates more instability.
Precisely. And if you implement unapproved rules and an employee challenges them, the court will just ignore your rules and go straight back to the Labor Act minimums.
Okay, this brings us to what might be the most contentious area and the source of a lot of labor unrest, defining permanent worker status. When does a temp or a casual worker legally become permanent?
This has gotten a lot clearer, thankfully, especially with the 2022 amendment to Rule 18. The rule is very clear now. If a specific job continues uninterrupted for 180 days, that job is legally considered a permanent job.
A permanent job, which requires permanent workers.
Which requires permanent workers. The 180-day rule is the trigger.
Let's talk about the casual loophole then. It's a common practice, right? Companies keep hiring casual workers on paper to fill core permanent jobs just to avoid giving benefits like gratuity.
And that's exactly where they get into trouble. The courts will look right past the title on the contract to the nature of the work itself.
So what's a genuine casual role then?
It's reserved for truly unplanned, sudden events. Think about a sudden need to clean up a site after an accident, or hiring a driver for just one day because the permanent driver called in sick. That's casual.
But not someone working on the assembly line every day for a year.
Absolutely not. If you're calling a worker back month after month to operate a machine on the main production line, they are, in the eyes of the law, a permanent worker. And the courts consistently side with the employee on that.
Okay, that clarifies the risk for core roles. Let's shift to another type of employee, foreign experts. How do they fit into this legal framework?
Most foreigners are brought in as high-level managers or technical experts, and crucially, those roles usually mean they aren't considered workers under the strict definition in the Labor Act.
So they're outside the scope of most of these local labor law protections.
For the most part, yes. Their employment is mainly governed by their individual appointment contracts and their work permits from authorities like BETA or BPZA.
Which also means?
It also means the Labor Act's disciplinary procedures like Sections 23 and 24, which detail how you have to investigate misconduct, those typically don't apply to them.
That is a fundamental distinction. Now let's tackle probation periods. There's always confusion about the maximum lengths and extensions.
The law is very specific and breaks it down into 3 categories. First, for clerical work, probation is 6 months, and it cannot be extended, period.
Okay.
Second, for an unskilled worker, it's 3 months, and that also cannot be extended.
And what about for skilled workers? That's where it gets interesting.
Right. For skilled workers, the initial probation is 3 months. But, and this is key, because they've claimed a high skill level that needs proper assessment, their probation can be extended by another 3 months. So a total of 6.
So they're the only ones with an extendable probation. What's the one critical mistake companies make here?
This is the aha moment you need to lock down. For a skilled worker, the letter that extends their probation must be issued before the first 3 months are up.
Before?
Yes. If you miss that deadline by a single day, the worker is automatically deemed permanent. Management completely loses the right to that extended assessment period. It is all about timing and proper documentation.
Okay, let's transition to how the law governs employees' money. Financial compliance. I think we need to bust some common HR myths, especially around unauthorized wage deductions.
Oh, this is a huge one. Wage deductions are under a very strict legal lockdown. They are limited only to the specific conditions laid out in Section 125 of the Act.
Anything outside that list is illegal.
Anything.
What about the common practice of, say, mandatory deductions for charity, like flood relief?
If the company mandates that deduction, it's illegal. A contribution has to be voluntary. The company can't just cut the wages. The employee has to be the one to explicitly agree and deposit the funds. It's a fine distinction, but a critical one.
And what about that classic 3 days late, 1 day's pay cut policy? You still see that around.
Absolutely not legal. Penalties for being late have to be strictly proportionate to the time lost. That's in Section 126. You cannot cut an entire day's pay, which is a massive penalty for being a few minutes late.
Moving on to mandatory profit sharing. The Workers' Profit Participation Fund, or WPPF. Eligible companies have to set aside 5% of net profit. Can you walk us through that split?
Sure. That 5% gets split 3 ways. 80% of it goes into the main participation fund, which gets distributed to employees. Then 10% goes to a welfare fund, and the final 10% goes to a government foundation.
It's that 10% for the welfare fund that causes a lot of internal friction, from what I've read. What's the conflict there?
Well, the legal objective for that 10% is pretty clear. It's meant for specific collective welfare purposes, things like emergency medical aid, education grants, or helping with severe hardship. And it's supposed to be managed by an independent trust board.
So what's the problem in practice?
The problem is the administration and, frankly, the internal politics. That trust board has to sit down and evaluate individual cases of hardship. And that can lead to resentment, friction, gossip among employees about who got money and why.
I can see how that would become a headache.
It's a constant administrative burden. So what many companies do, especially multinationals, is they just bypass that whole process.
Wow.
They just distribute that 10% equally as cash along with the rest of the fund. Now, technically, that goes against the legal objective, which is welfare, not a cash bonus. But they see it as a practical choice that boosts overall morale and mental well-being. It's a compliance risk many are willing to take.
We've saved the most complex and maybe the most ethically challenging issue for last. Workplace harassment, specifically sexual harassment. This area is a real legal jumble right now.
It's an almost impossible situation for HR leaders because you have two conflicting legal mandates on how to form the complaints committee.
Okay, lay out the two conflicting points for us.
Right. So point 1 is the 2022 labor rules. Rule 361. It says you need a 5-member committee chaired by a woman with a majority of members being women, and they all have to be internal staff.
All internal. And the conflict.
The conflict is a 2009 High Court ruling. It also requires a committee with a majority of women, chaired by a woman, but it mandates that you must include at least 2 external members.
External members. So a company has to choose internal per the rules or external per the High Court.
Exactly. And there's another dangerous gap, the scope of who is protected.
How so?
The 2022 rules only apply to formal employees. But the 2009 High Court ruling is much broader. It covers any woman in the workplace, vendors, customers, visitors. So if a woman from a supplier is harassed in your office, the High Court ruling kicks in.
And to make it even more complicated, sexual harassment isn't actually listed as a formal misconduct in Section 23 of the Labor Act.
It isn't. But any investigation still has to follow the process in Section 24, which means upholding the principles of natural justice.
And that's a huge compliance trap. You have to ensure the accused gets a fair hearing, the right to respond, all for something that isn't even officially listed as misconduct in the statute. It's a mess.
It forces companies to make these really complex choices under enormous pressure, all while trying to maintain fundamental fairness.
So when you put it all together, it's clear that labor compliance in Bangladesh is about navigating these vacuums. The general holiday, the direct conflicts like the harassment committee, the ambiguity around the welfare fund. It's not straightforward.
Not at all. And the ultimate goal, like you said at the start, isn't just to avoid a fine. It's about building a stable, fair, and productive workplace where that employer-employee relationship is clear. That stability is the real prize.
Absolutely. So, given all these contradictions we've discussed, the approval bottlenecks, the committee confusion, here's a final thought for you to take away. We know the National Committee is working on amending the Labor Act of 2006. So what's the single most urgent foundational change they need to make to truly stabilize things? Is it fixing the bureaucracy? Is it clarifying these committee rules? Or is it finally, unambiguously defining what casual work actually is? That's what you need to be thinking about.